So in the previous lesson, we talked about the introduction to administrative law on the one hand, and in this lesson, what we're going to do is talk about judicial review in a little bit more detail. So we touched on judicial review at the end of the previous lesson. We noted that one of the main ways in which we can see the imposition of, or the expression of administrative law is through the idea of judicial review. We also noted that the supervisory jurisdiction of the High Court gives the idea of judicial review a certain amount of authority. The constitutional nature of judicial review essentially allows for the upholding of basic principles of the rule of law. And in addition to this, we can come to the conclusion that what judicial review fundamentally is the ability for the courts to hold the executive branch to account, to hold executive authorities, whether that be departments of state or whether that be other public bodies, to account for their actions to ensure that they are not acting beyond their authority. This is known as the ultra vires doctrine. This lesson is going to essentially go into more detail on the subject of judicial review, as well as concern ourselves in the grounds for judicial review, which is going to be the main subject of the next few lessons, where we talk about things like illegality, irrationality, and procedural impropriety. This lesson is going to spend some time taking an introduction to the subject, as I noted, looking at its purpose and the necessary requirements for bringing an appropriate claim of judicial review in England and Wales. And the first thing that should be noted here is that judicial review can only apply to particular defendants. It can only apply to particular instances, specifically public bodies. So we noted that this is the first point of reference, that when we think about who can be subjected to a judicial review claim, the answer to that question is that it must be public bodies. They are the only institutions which can actually be subjected to a claim of judicial review, or in circumstances where it is a private body but they are performing and exercising a public function. And so what this means, therefore, is that when we think about judicial review and the potential claims being brought against certain institutions, we have to examine the nature, the purpose, and the functions that those institutions actually carry out in order to come to a determination as to whether or not it is going to be a successful judicial review claim. A public body simply refers to an institution which carries out public work. Public work generally refers to work which has an effect onto a general population. It doesn't necessarily have to be the general population in its entirety. It could be a specific subset of the population, such that it is a specific subset of the general population. It could include a variety of different institutions. It can be and is not limited to government departments on the one hand, so for example the Home Department or the Department of Foreign Affairs. It can be the ministers of those departments, so the Secretary of State for Education, for example, the Secretary of State for Immigration, the Secretary of State for the Home Office, the Home Secretary, all of which can find themselves in the light of a judicial review case. It could also refer to local authorities as well, again performing performing executive functions or performing public functions. Now, the case of Crown versus the Disciplinary Committee of the Jockey Club is one such example of where the courts have been invited to examine what it means to be a defendant in a judicial review case. This case concerned an example of which kind of institutions could be subject to judicial review, and it gave us an indication as to how this is determined. Was firstly the disciplinary committee of a jockey club able to be subjected to a claim of judicial review? Did it fit the bill for being a successful claim in judicial review? Well, the courts concluded that when deciding whether or not an institution is able to be subjected to judicial review, obviously we have to therefore decide whether or not an institution is a public body. In making this determination, there are a number of considerations that have to be examined. These considerations include the nature of the institution, it also includes the origins and history of the institution, as well as the constitution and membership of the institution. There needn't be an institution which is controlled by the government or the government authority necessarily. So this is something that should be subjected to a case-by-case analysis. Now, in addition to this, questions that also need to be asked is whether or not the body has been integrated into the system of statutory regulation, or potentially if it is carrying out a function which is ordinarily the remit of government, or even if it is performing some action that would be performed by an organ of the government if this institution did not exist. These are the kinds of questions that, when subjecting an institution to a case-by-case analysis, we come to the conclusion of whether or not they can be subjected to a claim in judicial review. Now, as a basic spoiler alert, the conclusion in this case was that the disciplinary committee of the Jockey Club was not considered to be a public body, and so the courts concluded that a judicial review case could not be brought against them. One of the things that's very important to note is that when bringing a case of judicial review, it is very important that we do not abuse the process, and in fact don't find ourselves in circumstances where we are being accused of an abuse of process. Once it has been determined that the body in question is a public body, then it must be determined that the action in question was a matter of public law. That is the next question. If it is not, then the claimants who brought the claim could be guilty of an abuse of process. In addition to this, if the matter in question is a matter of public law, and if the body in question is a public body, then it would also be an abuse of process to bring an ordinary claim of litigation and not a specific judicial review claim. So if it is the case that we are talking about and dealing with a public body, okay, if it has been determined that it is a public body, and if it has also been determined that the matter in question was a matter of public law, but instead of bringing a claim in judicial review, we decide to bring an ordinary claim in civil litigation, this will also be considered to be an abuse of process. The reason for this is because it would suggest that the claimant is trying to gain an unfair advantage throughout the process of bringing about litigation. Essentially, there are certain rules in place which protect a public body in certain judicial review cases. These rules in place, these protections in place, do not necessarily exist in circumstances where we are talking about an ordinary case of civil litigation. So basically, there are specific things in place which are essentially tailor-made for circumstances of judicial review claims. So it would be an abuse of process and essentially a claimant trying to gain an unfair advantage if they could have brought a judicial review claim, and it would have been most appropriate to bring a judicial review claim, but instead they do not, and they instead go for civil litigation as an alternative.